Hi, and welcome back to the show. I'm attorney James Betzold, and this is the Prima podcast, where we interview attorneys about cases they've handled, successes they've had, follies that they've endured. And we've been focusing recently on immigration attorneys who are taking cases to federal court. This has become more and more important over recent years because of the silliness that is coming out of all parts of the government. So we are joined today by attorney Courtney Rineer from Florida, and she shares with us information about asylum, employment cases, and where she needed to take a case to federal court to fix what we call a scrivener's error. You'll learn about that in the podcast today. As always, the show is brought to you by Prima.Law. Prima.Law is the immigration practitioner's preferred software for autofilling the forms, managing your cases, and getting that package ready to submit to either USCIS or the Department of Labor or to the EOIR, the Immigration Court. Now, autofilling your forms, of course, is going to be very important, especially when there's so much data you're dealing with. And if you need to do an update of something, or you want to just have to enter that one time and then fill in the remaining data on the forms, that's what you want to do. You want to save as much time as you can. You want your clients to give as much input as they can through questionnaires or uploading documents from their checklist directly to your case, so it is where you need it. Now, when you're finally ready to get all those forms filled out and populate, you want the finished product. You want to have that immigration packet or package ready to mail to USCIS or submit electronically to the EOIR. And to do that, there's rules you got to follow. Typically, the best practices are you have a table of contents with the exhibit numbers. So then you have an exhibit sheet separating each major exhibit, so it's easy to flip through. Even if immigration doesn't like it, you will, because you need to archive that file and you're going to have to refer to things quickly in the future. And EOIR does require it too. So what's nice is you can take all your forms, addendums, attachments, exhibits. You can automatically generate a table of contents with exhibit numbers and page numbers, so you know exactly which pages certain exhibits are found at, and you can put those page numbers on each page of your packet. So especially if you're dealing with one of these large ones, hundreds of pages long, maybe thousands of pages long, you are not going to have to go through and manually do that. And if you make a mistake and need to reorder something, it's just a matter of moving things around and generating the package again. So that's what we call package assembly. It's going to save you time, it's going to save you money, it's going to save you frustration, and we all know there's enough of that in the practice of law right now. So find a free trial at www.primafashinow.com. That's PRIMAFACIENOW.com. Enjoy the show. And again, special thanks to Courtney Rineer. Okay, here we go. Welcome. Thank you for joining us. I'm attorney James Betzold, and welcome back to the podcast. I'm joined today by attorney Courtney Rineer. She's a licensed attorney in the state of New York. She's been practicing immigration for the last 15 years, and her focus has been on employment immigration. Welcome, Courtney. Thank you for joining us today.
Thanks for having me.
My pleasure. So there's been a lot of talk recently about federal immigration court cases. So an immigration case that maybe gets rejected or denied or gets an unfavorable decision, and it makes us angry as immigration practitioners.
Yes.
Have you ever been angry at the government?
Yeah.
You know, I think if we're not careful as a community of immigration lawyers, we're going to end up forming militias because some of the decisions that are coming out of USCIS are just maddening and frustrating.
They are. They're really frustrating. Yeah. So I graduated law school in 2004.
Okay.
My first job out of law school while I was actually waiting to be formally sworn in and licensed in New York was at a law firm that primarily focused on asylum. About 95% of their caseload is asylum cases. And I was hired to do the brief writing and the preparations for Board of Immigration Appeals, BIA appeals, as well as federal court litigation in the New York Southern District. I was a brief writing machine. I spent my whole day poring over denied cases and making arguments on why these cases should be overturned. I dealt a lot with settlement conferences with the government's attorneys in the federal court litigation. And my goal was to try and get these cases remanded back to the asylum court so that the immigration judge could try again, and hopefully get the outcome that we wanted, which was asylum granted for our clients.
So you were actually taking these cases in EOIR, in front of the immigration court at first?
Well, my boss had. When he hired me, it was because they had gotten enough unfavorable decisions that he wanted to have a focus on appellate work. So he hired me to work specifically on the appellate piece. He was the one going into EOIR. He was the one going in front of the immigration judge and trying to get the initial decision. If it was denied, then he handed the case off to me. I took the transcripts, and which I know you know is volumes of paper to pour through and try and come up with the best legal arguments why the IJ got it wrong. The immigration judge made a mistake. And we usually would initially file the appeal with the Board of Immigration Appeals as a first step. And then if it was still denied at the Board of Immigration Appeals, then we would take it up to federal court. And we were successful with a lot of cases. And I know that some of the briefs that I wrote back in 2005, my boss used for many years later, used those same legal arguments in future cases. So
to give a little context for maybe some of the newer immigration practitioners out there, the EOIR, Executive Office of Immigration Review, that's what we call removal court or immigration court. That's the trial court for the immigration hearing, right?
Right.
And these asylum cases were heard there. So all the evidence is put on there. Judge says, no, for whatever reason, denies it. Now, I mean, there were a lot of, you said this about 15 years ago? Yes. About the last one. Okay. So, I mean, there's sort of a history of like EOIR having policies in place saying, no, by default, anything dealing with this is denied.
Right.
How did that play into like your appeal?
That actually, and this was, I know this doesn't exist anymore, but the majority of the cases that we were filing, or that my boss in his office was filing, were based on Chinese family planning. And it was really just a matter of showing that your freedoms had been infringed. You weren't allowed to have more children than one. That there had been, cases of forced sterilizations, forced abortions. They were mostly fact-heavy cases, and the requirements were you just had to show that you'd suffered this harm in the past and you were afraid to go home, right, in order to meet that requirement for asylum. That doesn't exist anymore because China changed their one child policy. So you don't really see asylum cases anymore that are dealing with Chinese family planning. But then it was it was the vast majority of the cases that we had. And because they were so fact specific, and you're dealing with people that came from small towns, rural areas, they didn't have a lot of the paperwork that you might find in a big city like New York, right? They just didn't have necessarily the evidence that you would expect. And at the EOIR level, my boss was very creative about, working with, other eyewitnesses and other testimony that could help. But the immigration judges didn't always believe the story. They didn't always believe that set of facts that we were presenting. And on appeal, we were really dealing with how is the law intended to be applied to this set of facts, and finding, areas where we could argue that the law should be applied to this set of facts to grant asylum. But that's, yeah.
So fast forward 15 years, people are still taking asylum cases in immigration court at the trial level. And I mean, we've seen just a number of bad decisions because this is the one area of the law where the attorney general can just say, I'm going to take that decision and I'm going to change it however I want it. And now that's law.
Yeah.
Unless it gets appealed to the Supreme Court or something like that. Right?
Yeah. And it's really hard because a lot of asylum cases, the vast majority of asylum cases are now being denied. I mean, back in 2005, I think it was a 35% denial rate, if I remember correctly. And now I know here, at least in Orlando, where my office is, it's about a 94% denial rate. So anybody that comes into my office now and says, I want to claim asylum, we say, let's look at all your options, right? Because, I mean, they may have a very good case. They may have a strong case based on the law, but that doesn't mean that the immigration judge is going to grant the case. And so do they understand what a long, hard fight that they're in for? And actually back in 2005, I changed gears and went from working primarily on appellate work in the asylum area to business immigration. I am an expert on PERM. I filed one of the first PERM cases. I've got one of the first approvals, and that is the employment-based green card process, which is still being utilized exactly the same way it was 15 years ago. And I also work on name a type of work visa. I've done one of those applications. Lots of H-1B work visas, L1s, E2s, E1s, which are fun, trading visas. And what we're seeing in the business world is that mentality that had existed, I think always in the asylum world, was how can we deny this? We're seeing that in the business world as well. So it's very frustrating for my foreign national clients, especially when they're coming here, they're investing money into the US economy, they're employing American workers, and they don't understand why it should be difficult for them to get the work visa that they need. But it is, because they're looking for reasons to deny. Where in the past, they were looking to see if you met the requirements. And if you met the requirements, you'd get the visa. So
does this have anything to do with you see on the USCIS's webpage, shortly after President Trump was inaugurated, you see the banner change, and it says, instead of, we're serving our mission, we're helping immigrants, it says, buy American, hire American.
Yes.
Which really doesn't have a place on an immigration agency website, if you think about it.
No, no, very much. And that buy American, hire American mentality is one of the things that influenced our most recent H-1B rejection that we recently took to federal court. We achieved a settlement in March, and the case was officially approved in April. So it's actually very recent.
Let's talk about that one. How did let's start at the agency level. What happened at the agency level that made you say, you know what, we got to appeal this?
Well, the first thing I have to say, for anybody that doesn't practice business immigration or who doesn't deal with H-1B visas, one very important thing to know about the H-1B visa program is that there are only 85,000 H-1B visas given out each year. And there are usually about 220,000 applications received in the first 5 days that immigration accepts applications. They open the window, they close it very quickly, and you still only have about a 1 in 3 chance of getting picked in the lottery for one of these visas. So getting picked in the lottery is a big deal.
1 in 3 chance. So you have to apply, meet all those requirements. Yeah. And then you're in a lottery.
Right. And in the past, they changed the lottery system this year, but in years past, you did all the work to build the case. You did all the research, all the writing, made sure you had all the requirements. It's a big, thick stack of paper that you're sending to a service center. And what they're doing is they're assigning it a number, a lottery number. And then they run a computer program that randomly generates the people that get picked, right? In this case, and it was very frustrating, we got picked in the lottery and we received a letter. We actually received our nice thick package back with a blue letter on top that said, although you've been chosen in the lottery, we are rejecting your application because it doesn't meet the requirements for to be approved. And really, it's so frustrating. I can't even talk about it still.
You get a number, but you don't.
I'm so mad.
You win, but you don't.
Right. So they were like, you got picked in the lottery, but we're rejecting your application because of a date entry in one box of a 36-page form that was a typo.
So rejections are not unheard of broadly speaking, in the practice of immigration. I mean, from time to time, it happens to every law firm, right?
Right.
You send out an application, some little piece of information gets missed or excluded or something like this, and they send it back. And usually they sent you a blue paper, so sometimes it's blue or green, but they'll say, hey, you sent this, but you forgot this. Send this back in, and we'll put you back in line where we had you. Usually that's how it was happening.
Yes, and in the past, actually, I would say prior to about 2016, in the past, that's what would have happened. They would have sent what's called a request for evidence, and they would have said, we've received your application, but we think there might be an error in it. Please correct the form and send in a new copy with fresh signatures, right? And that's what we would have done. And they would have gone ahead and processed the application. But that's not what they did here. And that's not what we were seeing talking to other immigration attorneys in the community. They were seeing rejections like this too. And most of them were for typos.
Do you know the legal term? You know the legal term for a typo? I'm sure you do.
Well, Scrivener's error.
That's the law school.
A Scrivener's error.
Scrivener's error. You got it. That's exactly it.
And I know this. I probably would not have remembered this, except that is one of the things in our first phone conference with the federal court judge. He asked me directly. He said, are you stating that this was a Scrivener's error and you want to correct it? Absolutely, Your Honor. It was a typo. It was a Scrivener's error. We want the opportunity to be able to correct it. That's what we're asking.
Look up what it means, right?
Right? No, I didn't even have to. And I think he was a little bit surprised that, and I had already had several, at this point, I'd already had several conversations with the government's attorney. And I admit it was a typo. It was my office made a mistake. Please don't punish the employer who's trying to hire a foreign national to do a job that he cannot find an American worker to do. This wasn't just any job, right? This is someone who develops software, and they've helped develop a proprietary software that this company uses. So in order to maintain and grow that software program, they need this guy, right? So because he has a knowledge base that you're not going to find even just with someone straight out of college, right?
It could take years to get another software developer up to speed on any proprietary software, talking from experience.
Yes, I know, you know. Yeah. And that's, the hardest thing about dealing with these sorts of rejections that are so frustrating for immigration attorneys, because that there's a mechanism in place that you should be able to fix these kinds of problems, and immigration won't let you do it anymore. And convincing an employer to spend more money and more time taking something to federal court, that's a big ask, right? That's hard.
Hard sell. Yeah.
Yeah. And luckily in this case, the employer happened to feel exactly the same way I did. He was angry, right? And at the end of the day, he was like, we got to fix it. How can we fix it and get this guy the H-1B visa that he needs so that he can come and work for me?
Let me ask you, let me get a practice tip from you then. Mm-hmm. All right, because I'm guessing, and maybe not, maybe I'm wrong. When he found out that there was a Scrivener's error, there was just one field on one of the many pages of the application.
36. Yep.
And it was your fault. I mean, did he verbalize that frustration? He or she, I guess.
Absolutely.
Yeah.
Oh, yeah, absolutely. And that's, so I'm the managing attorney I'm going to back up a little. I'm the managing attorney of my law firm. I have 2 other attorneys that work for me as well as support staff, right? At the end of the day, anything that goes out, it's my name on it. I'm the one that signed it. I'm the one that reviewed it. I missed it. I just didn't catch it. And I don't have an excuse for that.
Yeah.
And I'm not going to try and make an excuse. I'm not perfect. Nobody is. Mistakes happen. How can we fix it? And here, the only fix was federal court. It was not possible because this foreign national was currently here in what's called optional practical training. So he'd finished a degree here and he was here in a temporary status, gaining work experience in his field of study. Mm-hmm. He had a limited amount of time left in that current work visa status. If he had to leave and go back to his home country, he obviously loses his job. My employer loses the employee that they need, but him being able to come back could take years. Because again, that H-1B lottery, if you don't get picked, you got to just wait again and try the next year, a whole 12 months later.
It seems like an inefficient way to encourage employment growth in the United States. Let's do a lottery.
Yeah, and it's very frustrating, especially in the STEM field: science, technology, engineering, and math. Mm-hmm. The most recent data that I have seen was from a 2018 nonprofit that represents all colleges and universities in the United States. 87% of students graduating with a bachelor's in computer science, 87% of them were foreign national students on F1 visas.
Wow.
So it is 2018 and Americans have still not figured out that IT fields and STEM fields are the future for work.
Yeah.
So you've got all these American employers who desperately need IT professionals and cannot find qualified Americans to do the job because they're not graduating with those degrees. They're not gaining those skills and that knowledge that's needed for current work in the United States. It's very frustrating.
Yeah, it is. And you said, so there's 85,000 visas, H-1B visas giving out each year, right? Via the lottery. How many, do you know how many years it's been at that level? I mean, it seems low.
Well, so the law was changed, I believe, most recently in 2001, if I'm remembering correctly.
So like almost 20 years ago.
No, sorry. It was the late 90s. And then in the early 2000s, 2001, 2002, they actually increased the numbers. They greater than 85,000. But then Congress put a sunset in the law, right? So that number automatically went back down to 85,000 in about 2001, 2002. And we started seeing for a couple of years, there wasn't really a backlog. There weren't more applications than there were visa numbers available. But then by 2005, 2006, we started to see a backlog. And they put this lottery into place. They actually had to create a whole new set of regulations to govern this H-1B lottery system. And they just revamped it this year. This year was the first year that they've changed the way that they're doing the lottery, but they didn't increase the visa numbers that are available. So 2008, right, we had the financial crisis. So 2008, 2009, 2010, we saw a huge drop in the number of H-1B visa applications that were being applied for. Nobody was working, right? I mean, unemployment was high. Employers were not looking for workers at all, much less H-1B workers.
Well, yeah, I mean, everyone was still trying to recover from the housing bubble, right?
Yes. But then in about 2011, 2012, the numbers shot up as the economy recovered. Mm-hmm. And as especially STEM fields became so much more important, they actually put out statistics every year on how many applications they received. And for the last 8 or 9 years, they've had over 200,000 applications each year. And this year they actually had, and I don't remember off the top of my head, it was even more. It was something like 300,000 this year because they changed the way that they're doing the lottery. So, yeah.
So 300,000 people applying, 85 get a number. And not even, will all of those be approved then? Or is that, no, you can go for the profit?
That's an excellent question. Because no, the ones that in the past, and again, I'll say prior to 2016, they had about a 30 to 35% denial rate. And that was usually what the big thing about H-1B visas is that you have to show that the job requires the minimum of a bachelor's degree as a specialty occupation. Those are the big things that they're looking for in the H-1B context. Does this job require a bachelor's degree? So if you're going to be a cashier at a store, that doesn't require a bachelor's degree to do that job. That's not an H-1B job. And in the past, if you tried to apply through the H-1B process, that application is going to be denied because you don't meet the requirements for H-1B. Now we're seeing closer to a 67% denial rate in H-1Bs. And the big thing, and is this a specialty occupation? Does the job require a bachelor's degree? And they're looking at a variety of computer science jobs that they're saying, well, you don't really need a bachelor's degree to be able to do this. And they're basically trying to take STEM fields and turn them into more like data entry kind of jobs. Even if they're not. So if you're helping to write code and write, create a software or improve a current software, right? They're going to argue that what you're really doing is just data entry and it doesn't really require a bachelor's degree or it's not specialized enough. And that's their kind of go-to. And they've actually just recently, there's a really good article in Forbes. If you look it up on Forbes.com, it came out in March, I believe, that talks about 3 different federal court cases in 3 different jurisdictions in the United States that CIS lost all 3 of these cases because they said, the judges said that CIS was being too picky. They were trying to make the bar so high, no one could meet it, right? If it's reasonable, if other companies in your area require the minimum of a bachelor's degree for this job, then a bachelor's degree is a normal requirement.
So it seems like there's a little bit of a trend recently where like employers who are looking for software programmers or coders, developers, I mean, they're desperate enough where they'll say, even companies like Microsoft now said, you know what, if you don't have a bachelor's degree, whatever, just if you've got experience and you can do it, apply and we won't treat you any differently. How does that affect the whole environment?
I mean, I don't know specifically, but I do know that a lot of those companies are doing a lot of on-the-job training, right? In lieu of, right? And they're also encouraging people to continue on with their schooling. They need the background and they need the nuts and bolts of a system to really be able to thrive and grow, right?
Yeah.
But again, those have to be Americans, right? Because they're not going to meet the requirements to be able to get an H-1B visa if they're foreign nationals. Yeah. So yeah, if they're changing the standards in their industry, then yes, it's going to affect how an H-1B is going to be adjudicated and approved. And rightfully
still, you need, like, even if it's not, because is it bachelor's strictly, or can you get like equivalent work experience?
You can't. Yes, you can. And back in the day, that would work fine. So there's a rule in immigration that says 3 years of work experience is the equivalent of 1 year of schooling. So you could have, say, an associate's degree, which is 2 years of education, right? And then you could have 6 years of work experience. And that 2 years associate's degree plus 6 years of work experience is the equivalent of a bachelor's degree.
I see.
They're denying those all over the place now because they're saying it doesn't meet the requirements. Then they're saying the foreign national doesn't meet the requirements of having a bachelor's degree, even though they have the equivalent. So like I said earlier, they're doing everything they can to deny everything they can.
So you got angry, your client got angry, maybe a little bit with you, mostly with the system, I'm hoping, because that's where the blame really belongs.
That really was the problem. Yeah, because he's like, look, you made a mistake, right? And I'm hoping you're going to talk to the person, right? Like he definitely knows there's some consequences involved there.
And sometimes to talk to the person, we have to do that in a place called federal court. So tell us how, like, what were the next steps after you decided, you know what, we got to take this to the next level? What was your strategy from there?
Well, the first thing I want to say is that this was a team effort. I think any attorney that's thinking about going into federal court and filing a lawsuit in federal court You either want a mentor, somebody who's going to help you through the process, or you want a team. And for me, it was very much a team. I have two attorneys that work for me, Alice Burgos and Vanessa Wilson, and we took this case on as a team. The first thing we did with the initial rejection is we filed a motion to reopen. We sent, a letter to immigration and said, look, you shouldn't have rejected this. Please accept it. And had all the legal arguments, right, in that letter. It was about 7 or 8 pages long. They rejected it again, almost identical language to the first rejection. They didn't even discuss any of the legal arguments that we had made for why it shouldn't have been rejected. So with that motion to reopen, we had a little bit of a template on what we knew we wanted to argue in our complaint to federal court. But the first thing we did once the employer agreed to hire us to take the case to federal court is to do a lot of research. And we divided up, we had 6 main arguments that we were making. We divided them up among the 3 of us, and we spent some time just doing research. Were there any other federal cases out there? Had the Supreme Court ever talked about this? Were there any Board of Immigration Appeal decisions that might apply, or AAO, Administrative Appeal Office decisions that might apply that could either help us or hurt us in federal court? And there's really not much out there dealing with these types of rejections, right? And one thing that's really important to note, which we put in the motion to reopen, there's nothing in the law that says they can reject a case for this reason. And we actually—
I think that's an excellent point, by the way. I'm sorry to interrupt, but
go ahead.
It's so often, at least in immigration court, where ICE will make an ICE or DHS counsel, the government attorney trying to deport your client will say, Judge, this doesn't exist. There's nowhere in the law that it says you can even do this, when we're talking about administrative closure or any of just a simple docketing tool that the court, just because it's a court, inherently has, or before it was recognized that they have. They said, Judge, there's nowhere in the regulations that allows you to administratively close. There's nothing that allows you to terminate. There's nothing in the law that says this. So I think to take that weapon and to turn it right back around and say, wait a minute, there's nothing in the law that says you can deny it for this reason.
Right.
I think it's great.
Right. And it's kind of a hard argument to make, because that we as attorneys, we want to be able to say, look at this case. Look at this statute, look at this regulation. So what we did do is we looked at all the regulations that govern the H-1B visa process, the lottery process. How are things supposed to go as they're written? And what we're seeing, and not just in the H-1B context, but I think all across immigration, is USCIS is making up rules. They're making things up. And that's the biggest reason that you file a case in federal court, is arguing that CIS, Citizenship and Immigration Services, did not follow the Administrative Procedures Act. They did not follow the statute that governs the agency and the way that rules get made and the way that they get changed, right? And so in recent years, and this has really been going on for at least a decade with all the USCIS policy memos that come out, right? You get a policy memo that says, well, here's the regulation, and this is the way we're going to interpret that regulation. That's not the way that's supposed to work. They're supposed to go through an administrative rulemaking process, and they aren't, right? And with this case specifically, what USCIS wanted to use, their big smoking gun that, Courtney got it wrong, was the instructions on the USCIS.gov website, right? Now, the instructions are intended for the public. They're intended as guidance, right? Immigration's goal is that anybody should be able to fill out this form and file this application. In reality, we know it's so much more complicated than that, but they would and the instructions make it sound like it could be simple, right? But the instructions aren't based on the law. They're not based on any statute or any regulation. A high school dropout could have written those instructions, and immigration is treating them as though they're the law, right? And that was actually one of the first arguments that the government's attorney made in our first settlement conference was, well, you just didn't follow the instructions. I'm like, I don't have to follow the instructions.
Like that's a great argument to make as a lawyer. I don't have to follow the instructions. But you're right. It's like an ultimate piggyback argument, right? Because you have the Immigration Nationality Act, the statute passed by Congress, right? Probably debated over a little bit because people want this way or that way. But then each administrative agency has the ability to promulgate regulations based on the INA, on the statute.
Mm-hmm.
But then I don't remember where I saw it, or maybe I'm just making this up. You can enlighten me. There's one of the regulations that says everything, and maybe this is the one you're referencing, everything should be done according to these regulations and the form instructions published on the website.
That's
Is
just
there actually,
USCIS
I think there's a regulation
policy.
that says something like, is there?
That's just USCIS's policy.
Just their
right?
policy. Okay.
Yeah.
So they're trying to piggyback it into a regulation by saying
Right.
that then.
I mean, it would be like relying on a blog as though it were the law.
Or Wikipedia.
Right? That's right. Yeah. I mean, like if you're going to quote a news article, that doesn't necessarily make it true or make it something that you should determine someone's whole fate on, right?
No, I saw a meme about it. It's true. Trust me. It was a very witty meme.
Yeah. So we, the first thing we did was research, right? I'm backing up. You asked me about process, right? So we did the research. We all sat down together as a team and we started we came up with the outline based on the research we had done. And then we kind of went to our own offices and worked on creating a draft of the brief. We went back and forth. It was really nice getting to work as a team because it helped us refine our ideas, refine our arguments so that we were making the most concise, best arguments that we could think to make. And then we sat down and went over the complaint that we had drafted, made sure all the I's are dotted, all the T's are crossed, it looked good. And then we filed it. And that was very frustrating. I don't know how many of you out there have worked with the PACER system before, but that is the federal court's online database and website that you can upload your federal court litigation to the website, and then it gets disseminated to the government's attorney as well as the judge and the clerk of court. And so it's very archaic. It's very hard to use. It's the opposite of user-friendly. So it took a little bit of time to get it properly uploaded, to make sure everybody was properly served. And then we got an order from the judge with a pretrial conference, which was scheduled for April. We filed our case in December 11th, we filed. So this was way in the future. And my client was not happy about it because his employee was running out of time, right? But him running out of time ended up helping us in the end in terms of settlement negotiations, right? We were like, we can't wait. We can't sit on this, right? So the next thing that happened is we sat back and waited for the government's attorney to file their answer. And about a week before their answer was due, they reached out and said, let's talk about this. And they didn't want to settle. CIS didn't want to settle. And like the government's attorney was like, yeah, we're not settling. We're not, we'll take this distance. But in reality, we know that the vast majority of, I think not just immigration cases, but cases based on administrative law and agencies. So if you're filing something that's from the Social Security Administration or from IRS, I think most of those cases settle. Very few of those cases actually end up in front of a judge with an actual written order by the judge on the merits of the case. The vast majority of them settle. I don't have statistics on that, but I know in the immigration world, that's what we're seeing, is that most federal court cases are going to settle. But at the beginning, like he was, yeah.
They took the posture of, oh, no, we're going to be hard on this. Forget it. We're going distance.
Yeah. You screwed up, not our problem. You're out.
Have you seen that with other attorneys, maybe in prior cases that you've handled? I mean, obviously with ICE, there's really nothing to negotiate about.
Right. Well, that's the lovely thing about federal court. There's everything to negotiate about in federal court.
Yeah.
And I mean, in a way, I felt like the government's attorney that I was dealing with had been in-house counsel for CIS. So I felt like they should have a better understanding of the way things are supposed to work. But he was very surprised when I said, look, in the past, this would have been a request for evidence. This would have been, there's a mistake here, fix it, right? And we didn't get that. And he's like, no, they never do that. I'm like, well, they haven't because they've done it for me. So, and then the other big thing is part of our research, we reached out to, and I got to say, this is one of the things I love about being an immigration attorney. I love the collegiality among my colleagues. Immigration law is hard. It's one of the most complex areas of law that you can practice. And we deal with so many different agencies, so many different sets of statutes and regulations. It's hard to do this work. And it's really nice that you can reach out to people and say, hey, have you seen something like this before? And actually what I did, and I'm the ambassador for the American Immigration Council, for the American Immigration Lawyers Association Central Florida chapter. That's our local bar association for immigration attorneys. I help disseminate information from American Immigration Council, which is a nonprofit arm of AILA that helps people litigate in federal court and other appellate courts like the BIA and the AAO. They provide a ton of good information. If you haven't checked out their website yet, I highly recommend it. They post really informative articles which help educate not just other attorneys, but also the public on what's happening on the ground in immigration. They have a staff of immigration attorneys that their job is to file federal court litigation or to help other attorneys, to co-counsel with other attorneys to file federal court litigation. They're a huge resource, and I'm so thankful that we had them to help us in this case. I reached out to one of the litigators on their staff and I said, hey, I've been looking through your website and I've seen some information on H-1B specific federal court litigation, but have you ever seen something that's rejected for a typo? Have you ever dealt with something like that, or do you know someone who has? She put me in touch with someone who had the exact same issue as me. Here was the difference. When they filed their lottery application, they filed with premium processing. So premium processing gets you in for an extra fee. You get an answer in 2 weeks, but you also get an email for an immigration officer. And that email for the immigration officer gives you direct contact to the person that's making a decision on your case. So they rejected the case based on the typo in the same field, the same date box, the same everything. And when it was rejected by email, this attorney reached out to that officer at immigration and said, hey, I think you've made a mistake. And they said, no, this is the way we do it. And he made the argument, like, pretty much a lot of the same arguments that we were making, and said, hey, please reopen this. And they reopened it. And the guy got his H-1B. So I'm talking to the government's attorney and I'm saying, yeah, see, you have reopened these cases in the past, so you're going to reopen this one too. No, we don't do that. You don't have any proof of that. So he asked for an extension of time to answer. And we said, no. We said, look, time is of the essence. We cannot wait. We don't even want to wait till April for the first settlement conference, right? Pretrial settlement. We don't want to wait for that. We want to get in front of the judge as quickly as possible. Mm-hmm. Help us make it happen, right? And, the government's attorney was not happy that we weren't granting an extension on time. So he filed a motion to request more time. And the judge turned around and said, hey, what's going on here, guys? Right? He wanted a phone consultation. And he said, let's see if we can have a meeting of the minds. Right? And the judge in the first conference, like the first thing he asked me was, is this a scrivener's error? Are you claiming that this is a scrivener's error? Absolutely, I am. Right? I just want the chance to fix it because I know if I can fix it, this application is going to get approved. So we're asking for you to reopen the case and adjudicate it. Let us fix the form and just adjudicate it. We're not asking for an approval. We're not asking for anything special. We're only asking that we get the chance.
So This case that you brought, this was under the APA then? Is the APA case?
Yes. Yes. We were basically saying, you know, they're trying to make up rules on the instructions, right? Like they didn't go through the rulemaking process that they're supposed to go through. So either to go back and go through the rulemaking process and change the rules, but for right now, based on the rules as they exist, you have to reopen this case.
So is this a claim that's called like an arbitrary and capricious claim?
Oh, yes. All over the place. You say arbitrary, capricious, and an abuse of discretion. That's
there we go.
every arguments, and every single one of them started with this was arbitrary and capricious and an abuse of discretion, and it ended with you have to overturn this because it's arbitrary and capricious and an abuse of discretion. Yeah. So that's, you know, the government's attorney was saying, he's like, well, you know, CIS is not inclined to settle this case, Your Honor. And the judge was like, well, over a scrivener's error, I think that I'm going to encourage you to speak with CIS again concerning the possibility of settlement. So, I mean, the judge was like, why are we talking about this? You know?
It sounds like it when I've dealt with attorneys who take that attitude in a negotiation or something like that, usually they haven't talked to their client about it. Usually they're just positioning, you know?
I've got to assume because you're representing the entire agency that you've at least had a conversation with someone at the agency. I mean, I don't know. But yeah, the government's attorney dug their heels in for a long time. And you know, one thing about filing something in federal court is you never know how it's going to go, right? The judges are inclined to give agencies a lot of deference, right? And that's actually when Congress created the agency, they created it to basically take the work off of their plates, right? They're like, here's the laws we want you to interpret and adjudicate. Now, because you have the expertise in this area, we're going to let you do whatever you want to do in that area, right? They have an incredible amount of deference. So you never know going in front of a federal court judge if they're not going to just come down on the government side because they want to show that deference to the government agency. And I've got to say, we found out while we were finalizing our settlement, and we found out that another case had been filed, exact same typo issue, same date box on the form had been filled out incorrectly. And that case lost a motion to dismiss. The government filed a motion to dismiss stating that, you know, the attorney didn't file the form the right way. And according to the instructions say you have to fill out the box this way. And because he can't follow the instructions, then he shouldn't be allowed to continue with this appeal. And the judge sided with the agency.
Oof.
Yes. Oh. So you never know. And I mean, we didn't get far enough to get in front of the judge to have to make that argument. But like, I wish that the attorney in that case had said, wait a second, the instructions aren't the law.
Yeah.
That's right. That was what was missing, you know? And the judge relied on those instructions in her written decision, granting the motion to dismiss. So you never know how it's going to go.
And the instructions are just terrible too. I mean, because they'll change them. And it's not like they email everyone to let them know, hey, by the way, we updated the instructions.
Right.
Like in a lot of the U visa cases or T visa cases. And I think they're doing this with almost every USCIS form now. All of a sudden, they're saying, hey, you got to put NA in the field if it's blank. You can't leave anything blank anymore. And they say, well, and if it's asking for a number and the number is 0, then you got to put in the word none. But what they don't tell you is that, and I know this because I've ripped apart their forms and looked very closely at them individually, all fields, and in every single drop-down menu, there's no option for NA.
Right. And so you end up you print out the form and you have to hand write it because otherwise it could be rejected. They would reject the whole package. Right.
Yeah. And so it just goes to
And I
show they're
think-
trying to be difficult. They're just trying to be obstructionist and try to slow down the
Right.
process and discourage people from wanting to file. I think what they're trying to do is to put immigrants against their attorneys so that they just
Yes.
give up and don't want to immigrate at all.
Right. Yeah, I do. I think that's true. And I like talking to other attorneys that practice in other fields of law. They don't understand how onerous the system is, right? I mean, I'm sure you've heard that before. Like, oh, it's just filling forms. Like, all you do is fill out the form and then you just get the decision. It's so far from the truth, right? It's so much harder than that. And it's really like, it was kind of fascinating because one of the things we knew going in front of the federal court judges, they don't know anything about immigration law, right? So a lot of the complaint was educating the parties about the process, right? This is the way it's supposed to go. This is what the regulations say, and this is how things have gone in the past. And then trying to explain the changes and how the changes are arbitrary and capricious, right?
Yeah.
But that's,
I mean, who does it hurt if a field's left blank? Nobody. Because if the government still has questions, they can send an RFE.
Right. But that's, and I've wondered about that. What I've wondered if, has enough immigration attorneys had some problem filling out a box that they ended up leaving it blank when they shouldn't have, or it's missing a number that it's supposed to have, and then it gets denied. And then they appeal it, right? And they appeal it, and CIS loses that appeal, right? So I think this might be CIS's way of saying, we're not going to let you get these cases overturned for what you think are Scrivener's errors. Because if you wrote NA in that box, then you thought that box didn't apply to you. So it would be harder to appeal, right?
Yeah. Well, the thing is, if you look at the way that some of the questions are worded, I mean, some of them are yes, no questions. And some of the way that they're worded, it's like they're trying to trick you. You know, have you ever committed a crime for which you were not arrested?
I love that.
Well, everybody does. First of all.
Right.
Second, is that really a yes, no question that you're going to get an answer to?
Right. Right. And that's it. It's very,
or if it's one of those where it says, hey, does this situation ever apply to you? Yes or no? If no, did this or this ever apply to you? Right. Well, now you've got a conditionally answered question. Do I have to write NA next to every bloody checkbox? Because a checkbox is binary. It's yes or no. It's not NA. So
right.
They're just trying to be difficult.
They are. They're trying to be difficult.
And I think that's the kind of thing that's really good. And it's, good on you for bringing that case and showing the agency. I mean, the judge, ultimately, end of the day, judge is like, next case. But the agency's learning, and the authorities are learning.
Right. Well, and I think really what the agency needs to be understanding right now is that we're not going to let these things go anymore. Right. This has been so egregious for so long. We're not going to let it go anymore. And, after we got the settlement with CIS, and part of our settlement was that they had to give us an answer in 2 weeks. So we weren't actually filing for premium processing, but we were asking for them to treat the case as though it were filed premium processing.
Which is fair because you'd filed it months before.
Almost a full year before. Yeah. Yeah. So yeah. And two, again, time is of the essence. The foreign nationals running out of time on their current status. We need a decision, right? And of course, the decision we got was a request for evidence.
Of course. And well, I think that's probably a typical trick in the.
Well, but I honestly, and I told the employer, I said, look, and the request for evidence was on that specialty occupation issue. This is not a job that requires the minimum of a bachelor's degree to perform the work. They've just lost all these cases in federal court on this exact issue, right? And I told the employer, I said, look, if this case gets denied on this issue, I will take it back to federal court for free because I will make sure that CIS is paying my fees. And trust me, my hourly fee just went up.
Oh, yeah.
I was so annoyed with this RFE. In the H-1B regulations, you can meet one of 4 criteria to show that it's a specialty occupation, right? So for example, you can show that you've hired other people in the same position, same job titles, same job duties, and they have a bachelor's degree. If you can show other people in your industry, right, in a similar job title, similar job duties, they have a minimum of a bachelor's degree. That's a second criteria. That's a second way to show it. So out of those 4 criteria, we met every single one to show that it was an H-1B. And I was like, look, if they deny this, I promise you we are not over. We are not done.
Things gonna get real if they deny this. Things are going down. We're gonna form a militia. We're gonna buy guns. We're gonna march on the cap.
Usually my request for evidence, I'm like, oh, well, maybe you didn't understand this part. Let me give you some more information. My tone is very definitely
that passive aggressive tone in there. Like,
no,
let me teach you something. I drop out.
I sent the request for evidence to one of my associates, and I said, will you please read this for me? Because I knew that I was ripping them to shreds with every sentence. I was like, without actually saying, are you idiots? Are you stupid? Like, and my associate wrote back and was like, you seem very upset. I'm like, that's the tone.
And I'm angry, Courtney.
So I did. I sent a rather scathing answer to the request for evidence, but then it got approved 2 days after we sent it. 2 days. They were like, ooh, quick, get rid of that one.
Any feeling on whether the RFE is like a stall tactic for them to buy a couple more days or cover themselves?
I mean, in that case, I to be honest, like, I don't want to blame all the immigration officers out there for doing a bad job, because I don't think they are. They have bosses. They have people telling them what to do. And I think the policy is, especially on like H-1B cases, they're saying, no, you have to send out at a bare minimum a request for evidence on specialty occupation, because we want you to deny. We want them to give up. And that's the orders on high, right? And that's, the policy has been deny everything.
Unbelievable. So ultimately, favorable outcome for your client. How happy was your client?
Oh my God, over the moon. So ecstatic. Although the foreign national, he was such a warrior, and naturally, right? And he was so concerned, what happens if this doesn't get approved? What happens if I can't, I don't want to have to leave the country. I want to be able to stay here and stay working. What are my options? What are my choices? He did not believe that it was really approved until he actually got the paper in his hand. So it took a couple of weeks before it hit him, right? That he's approved and he's good and everything's okay. So
like something so good finally happened. It's unbelievable, like literally hard to process.
Exactly.
Yeah.
But it's worth it. And I would say to anybody, especially, I actually had another attorney recently come to me here in Orlando. He recently had an L1 denied, and that he's thinking about filing in federal court. And so he's like, look, I don't know if I want to do this by myself. Would you be willing to co-counsel with me, and we'll work it together? I'm like, oh yes, we'll just bring you in. You can be part of the team. Well, it worked well last time, right? And he's the one that has the most knowledge of the case because he filed the original petition. And he's like, I just can't do this. I can't do it by myself. I'm too angry. And I know I'm not going to keep the level of decorum that I need to keep, especially when it comes to settlement negotiations. I'm going to get mad and I'm going to take it out on everybody around me. And I'm like, okay, good to know. But I remember being there. I remember feeling like that. And I remember thinking, I want to file this in federal court because it's not fair. Right? They're not doing things the way that they're supposed to. So I'm excited that we might be able to help somebody else go through this process. And again, like the reason that the L1 was denied, it's the reason they're denying all the L1s, and there's no basis in the law for it. So I think it's going to be a good case. I think it's going to be a strong case. And I know another similar case that settled here in Florida in federal court. They reopened the case and they granted the L1 in the end. So and that's the hard thing is with all the settlements, you don't have written decisions to look at and say, well, This is the way we did it before, right? Mm-hmm. So we're trying to create a network of of attorneys that are doing federal court litigation that are willing to share their experiences, not their clients' details, but talking about like the legal issues, right? Like an H-1B rejected over a typo. If you have something like that happen, call me, because I am happy to share the legal arguments that we use, the case law we relied on. That's, all of this, it's too hard to try and do it on your own. But I think that we have an opportunity to make a difference if we really start taking CIS to task, right? They have to understand that we're not going to be bullied. We're not going to give up.
And it's almost like, after 15 years of dealing with them and having to tell clients, look, man, you got to just wait. Look, I'm so sorry. It's taking 5 years for them to even look at your petition. I'm sorry, you've been delayed. Your N-400 has been delayed. You can't be a citizen yet because apparently they're suspecting you of being I don't know. They don't even know. They're not even really suspecting you. It's just got to have something that you can do to say, okay, that's enough, guys. Let's do your job, please.
Right. Well, and that's the other side of federal court litigation is the writs of mandamus, right? When things are so far outside of normal processing time, you can go to federal court and say, please ask CIS to do their damn job. That's all we want. They're taking way too long on these types of applications. We just want them to take each application and do it in a timely manner. And if they're not going to, then somebody's got to make them, right? And the only mechanism we really have is federal court. So it's expensive, it's time consuming, it's a risk because you never know how it's going to turn out. But
from what we hear, it sure sounds like it turns out great most of the time. Or at least very frequently enough to try.
Right. Yeah. Well, and that, like that other H-1B case that was in a different court, right? In a different state that different judge lost the motion to dismiss. He filed with the Court of Appeals. He didn't let it go. He kept going. So I'm still hopeful that, and then in that case, if we could actually get a real written decision that said, no, this is the way you're supposed to do it.
And you can cite it everywhere.
Everywhere.
Yeah.
Everywhere. Yeah. So.
Awesome. So like you said, just briefly, one point about PACER, because when you look at these different kind of immigration cases out there and you're like, oh, I want to see the complaint that Attorney Rineer filed in there. I want to go look it up on PACER many times because it's dealing with immigration.
Yeah.
The only people who have access to the record online, at least, are the attorneys.
Yes. Yes.
Which makes it so much more important that, we find each other, we get together, we meet up, share our experiences, share templates, share complaints, share responses to motions, offer trainings to each other, things like that. It's just, it's such a powerful thing we have now. I mean, imagine trying to do this, 20 years ago. You would probably have to specialize in law school and then intern with a judge in the federal court system in order to have the wherewithal or concept of how to file this and have an idea of how it's going to go.
Yeah. Well, and I actually, filing this case, because I hadn't filed one in such a long time, I reached out to a local attorney here in Orlando who had done some seminars and done some talks on federal court litigation. And I reached out to him and I said, can you help me out? Can you help me, like, procedurally, logistically, what do I need to do to get this thing filed, right? And he was so welcoming and so happy to share his time and his knowledge. And I really appreciate that. I appreciate that there are attorneys out there that are willing to do that. I know in a lot of other fields of law, the attorneys are very competitive. And I love that we're not,
what's funny, about 10 years ago when I was just starting in our area, it was ultra competitive. It was like, yeah. I mean, I had signed up for, through Ayla, I signed up for like a mentor. And so I was like sending emails and stuff. I'm like, hey, I got a question because I'm taking these cancellation of removal cases in immigration court, and I'll be darned if it doesn't seem like they're all losers. Do any of these actually win? Because I go and I watch hearings and those people lose. And I've, interned at this place or that place and all those cases lost. And I'm going to all these master hearings and everyone's depressed and looking down and just basically counting the days until they can delay their case more. Is this actually something that will win? And the response I got back was like, well, that's the trick, isn't it? I was like, okay, thanks for nothing. But you're right. It's different today. And I think in large part, it has to do with Facebook, social media, us just being able to connect with each other, meet each other online, share those anecdotes, vent a little bit about things.
I think it's CIS's tactics of trying to convince us not to keep going, that we've actually bonded, right, over the struggle. And I think it's brought us closer together, even if you and I, we're not in the same state, right? But we have experiences to share and we can learn from one another. And that's huge. And it's a very like us against them mentality, where in the past, maybe not so much, Yeah.
And I think it helps the immigration bar, the attorneys who practice immigration, come together, share information, and, ultimately just improve things. I mean, there are so many bad decisions from USCIS that even if all of us started doing nothing but federal court litigation based on them, there would still be a glut of more cases to take. So there's just no reason not to work together and fight the power.
Yeah.
Fight the law. We don't want the law to win. We want to win.
But I would say to anybody who's out there who's watching it, give one of us a call. We're happy to share our experiences and share our time.
Yeah. I mean, that happened with me too. I reached out to a number of different attorneys when I was filing, one of my first immigration related federal court cases. And it was like, oh, hey, you're going to do this? Great. Hey, let me tell you what to look out for. Here's what you should file. Don't bother about this. Put that to the side. You don't care about. Do this instead. That way everybody's happy.
Right.
Saves time and money for everyone. Makes the world a better place. Courtney, thank you so much for joining us today. I am absolutely positive that the information you shared is going to help and inspire others to do the same. If you want to reach out to Attorney Rineer, you can reach her at magnoliaimmigrationlaw.com. Again, she's got 15 years of experience under her belt, focusing on employment immigration, but experience in, it appears, all aspects of immigration too. So thank you for joining us today.
Thanks for having me.
Our pleasure.
This is great.
All right. We'll see you next time.
All right. Bye.